William Trice, deputy, please.
And that's why we try.
No problem.
I'm just waiting for the court recorder to come in, Counselor.
Absolutely, thank you. And I also want to thank the court for calling this matter promptly. I appreciate it.
No problem.
Your Honor, is it possible before we go on the record while we're waiting for the reporter for me to briefly go in a breakout room with Mr. Trice?
Yep, hang on 1 minute.
Thank you.
Hey, Ashley,
I'm doing it right now.
she's gonna put you in that breakout room.
Thank you.
Yeah, wait. Counselor wants to go into a breakout room with her client. Hey, Ashley,
For you.
Yes, Karen.
is Detective Showers gonna zoom in?
Consider meeting?
I will get
No.
him on right now, Karen.
When she
Alright,
can,
thank
she
you. I'm not used to sitting this tall. I feel like I'm 6 feet in here.
He will be signing in momentarily. He has to get his file.
Okay.
And we're just waiting on Detective Showers.
Thank you.
Hey, Ashley,
Yes,
was Detective Showers in the building?
yes.
Okay.
That's what I was just saying. I don't know where he is. So give me just a minute. Sorry,
Okay.
guys.
No, that's all right. Detective Showers, can you hear us?
I can.
All right.
Can you hear me?
Counselor, can you hear me?
Yes, Judge, I can hear you perfectly.
All right, thank you. Calling case number 20-99424, William Trice Jr. Mr. Trice, can I have you state your name for the record?
William Trice Jr.
Counselor, if I can have you state your name first, spell your last name along with your P number, please.
Yes, Your Honor, I'd be happy to do that. Camilla Barkovic, Barkovic, last name first, Camilla. P number is 78254, and I am appearing on behalf of Mr. Trice, who is present by way of Zoom.
Thank you. Mr. Trice, today's your date and time set to be formally arraigned. It's alleged on or about October 14th of 2020 in the city of East Point. You have a 2-count complaint. Count 1's assault with intent to murder. Did make an assault upon Antron Jones with the intent to commit the crime of murder contrary to MCL 750.83. This is a felony, life of any number of years, DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in the place of confinement. Count 2 is weapons. Felony firearm, did carry or have his or her possession a firearm, to wit, a pistol at the time he or she committed or attempted to commit a felony, to wit, an AWIM or ADM, contrary to MCL 750.227 parent B. This is a felony. It's 2 years consecutive with any preceding any term or imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon or device pursuant to MCL 750.238. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition, if not taken at arrest. Mr. Trice, you understand the alleged charges?
Yes, Your Honor.
Thank you. Detective, can you give me a background, please?
Yes, Your Honor. Looking at Mr. Trice's CCH dates back to 2005. He was convicted out of 16th Circuit Court in 2005 for assault with intent to do great bodily harm. That was adjudicated for juvenile disposition. In 2009, he was also convicted out of 16th Circuit Court for assault with a dangerous weapon. In addition to felony home invasion, he pled guilty to both. He was sentenced to several years in prison, Your Honor. I'm looking at 2009 as well, out of 16th Circuit. Mr. Trice he pled guilty to felony accessory after the fact. I believe that was also concurrent with his sentence in prison.
Okay. Do you have a bond recommendation, Detective?
I'll leave that up to the court, Your Honor.
Thank you. Counselor, do you want to be heard on bond?
Absolutely, Judge. So to make sure I have it clear, his last criminal convictions were entered in 2009, which was approximately 11 years ago. CCH is only one factor that this court can consider when imposing the amount of bond. I will tell the court that I am asking for a personal bond at the present time. I would indicate for the record that my client has been in custody since March 4th. He was not aware that he had a warrant. I actually met with his family members over the weekend and was provided with a copy of a letter that was sent by his prior attorney, James L. Galen Jr., to Detective Showers on February 3rd, 2021, indicating that he had been retained by Mr. Trice and that Mr. Trice would be essentially fully willing to cooperate and turn himself in if a warrant was authorized. It further confirms that the detective would contact Mr. Galen upon issuance of a warrant so that my client could voluntarily appear. Apparently that was never done. The reason I'm telling the court that is it shows my client's good faith and interest in addressing this matter promptly. I would also indicate that my client is actually the victim in this case. I also have been provided with certain evidence tags which clearly identify Mr. Trice as being the victim of a shooting. That's corroborated by the fact that my client was shot directly in the chest during this incident. He was in the hospital. He actually died, I believe, 3 times, Your Honor. He was resuscitated as a result of the gunshot wound he suffered at his own residence on the date in question, when he was ambushed by a third party. He suffers from a number of significant and severe medical conditions. In fact, the defendant actually has no spleen at the present time, which renders him unduly susceptible to infection. He also suffers from diabetes and multiple other complications from being shot in the chest. As a result of his diagnosed medical conditions and complications as a result of the shooting in this case, he's on numerous medications, which apparently he has been deprived of while he has been in custody. He's a lifelong Michigan resident. He's 30 years old. He has strong family support. He has a 2-year-old son of his own. If released, he would reside independently in his own apartment in the city of Bloomfield Hills. I would also indicate that he was working prior to COVID, but was unfortunately laid off. Any concerns that this court may have with respect to the fact that he was picked up in West Virginia are clearly alleviated by the fact that he hired Mr. Galen, corresponded with the detective promptly, and indicated that he was voluntarily willing to cooperate with this investigation. And in the instance, a warrant was issued. He hadn't heard anything, and he simply went there to attend a college basketball game. I'd be happy to address any other concerns that this court may have. And I don't want to get too much into the facts of this case, but I also have photographs depicting a third party at the defendant's residence on the date of the alleged offense, possessing a gun, pointing it directly at his residence. So in my opinion, the likelihood of conviction in this case is nil. And I believe that this defendant should be released on a personal bond.
I understand everything that you've indicated on the record. Due to the fact count 1 is a life for any number of years. It is alleged in count 1 with assault with intent and murder. The court is going to do a $250,000 cash surety only. I am going to refer it to community corrections.
MDOC number 280.
Due to the fact in relation to the medical conditions that you indicated on the record in reference to Mr. Trice.
586-445-9.
Your Honor, respectfully, I do, if the court would like to see him now, I do have copies of his medical records so we can avoid going through community corrections. They're never going to get these, and they're not going to be able to corroborate anything. Plus $250,000 is effectively no bond at all. And I'm telling you, not only is the defendant presumed innocent at this stage of the proceeding, but I have evidence suggesting, in fact, that he is and he will be acquitted. So I'm asking this court respectfully to reconsider the $250,000 bond amount. If the court's concerned about risk of flight or public safety, a tether could alleviate the court's concerns.
At this time, Counselor, due to the fact count 1 is a life offense, I'm going to deny your request. You always have a right to file a motion. If at best you can do an emergency motion up at circuit court. Due to the fact that count 1 is alleged, I do understand everything that you do have indicated. Today's the date and time set to just be formally arraigned. You're pretty much laying additional stuff out that can be determined at the probable cause conference, and it should be left up to the county prosecutor. And some of the matter that you're actually bringing up is actually for a jury to decide, not really for me to decide at this time as to whether or not if the case should be moving forward at this time.
Well, Judge, just respectfully, obviously I'm highlighting these issues for the court because they're relevant to factors that the court's instructed to take into account when imposing the amount of bond. Likelihood of conviction is clearly one of those factors. And so I do believe that what I have stated is directly relevant to that factor and mitigates the serious nature of the charge.
I understand that, Counselor. As I stated, I'm not going to lower the bond. I am going to refer it to community corrections. Community corrections has the authority to meet with him and to ascertain whether or not, if at all, if he does have those medical conditions, to do a referral back to this court as to whether or not to lower that bond for his medical concerns.
Thank you, Judge. In the meantime, will the court enter an order requiring the Macomb County Sheriff's Department to provide him with all necessary medical treatment and medications?
Sure, I don't have a issue with that. The court will go ahead and require that Macomb County Sheriff give Mr. Troy all the medical necessities that are required. And we're gonna bring him back for his probable cause March 30th at 1 o'clock.
Your Honor, he's not going to waive his right to have his PCC within 5 to 7 days under the court or under the circumstances in light of the bond that's been imposed. So I would ask that the court schedule a PCC as required by MCL 766.4.
Okay, well, we can move it to March 23rd, but I don't know if the Macomb County Prosecutor's Office is gonna be able to do anything on March 23rd. But we'll go ahead, we'll move it up to March 23rd at 1 o'clock. Counselor, is there anything else that you want to be addressed at this time on behalf of Mr. Trice?
Your Honor, I've addressed the issue of bond. That is the only matter that's up for determination today. So no, but thank you for the opportunity.
All right. Have a good day.
Thank you. You too, Judge.
Bye-bye. Mr.
Thank
Trice,
you.
you can spin around there and knock on that door and the deputy will let you out, okay? Now, who does the judge have? Who is the judge?
Probably this Webster, not. Thank you.
Sir, Webster? Webster?
Okay, Karen, so I think we have to log off and let Julie talk to all the other people. And then restart your meeting in room 4.
Yeah, no, it was mailed back to us.
Well, don't we have to,
Yeah.
because there's an attorney Ted Wallace, an iPhone, and Alexis Armstrong. And now they just brought the other,
Julie hasn't talked to anybody.
okay, well, they just brought another defendant in the Macomb County Jail.
Right, I don't know why they did that. He's there, he needs to talk to Julie, but we have to get it situated first.
Right, so you want me to completely log off this?
Yeah, we have to log off your meeting and restart it in room 4.
Tell her to make you the
Okay.
host.
I am the host. What do you mean?
Host or a co-host?